The next matter to come before the court is 729 West 130th Street LLC et al. Versus Hinckley Township Board of Zoning Appeals. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve any time for rebuttal, I ask that you let me know when you get started. I'm keeping track of the clock, and that helps me keep track of the passage of time. The arguments are being live streamed and recorded and will be posted on the court's YouTube channel. For this reason, please don't use the names of any minors or victims. I don't think that's necessarily an issue in this case, but we'd like to continually make that admonishment to make sure that attorneys understand. The judges have read your briefs. We are ready to proceed when you are.
Thank you, Your Honors. My name is Will Muniak, and I'd like to reserve 4 minutes for rebuttal.
Certainly.
Thank you. I am counsel for Brent Rumis and 729 West 130th Street LLC. In this case, I might refer to them as 729 West because it's a mouthful. But these two individuals are the owners of property located in Hinckley at 729 West 130th Street. And there are two owners, again, Brent Rumis and 729 West. And historically, this property has been used as a tavern for some time. And after COVID was wrapping up kind of in March of 22, March 15, 22, Brent Rumis, one of those owners, received an email from the zoning inspector of Hinckley Township, Tom Wilson. And that email indicated that the property no longer qualified as a non-conforming use, and it was a non-conforming use. And the reasons for that, because the liquor license wasn't in force, according to Mr. Wilson, as of January of 2019, but those issues are not before the court today, because the BZA, the Board of Zoning Appeals, determined that the appeal to the board was untimely because it wasn't filed within 20 days pursuant to Section 519.15 of the Ohio Revised Code, which leads to several decisions which I've articulated in the brief. I'm not going to go through them, but was this a decision? Was it served on both landowners, and did it comply with constitutional due process requirements? And I understand that this is a court of reviewing legal analysis or issues of law, but the facts in this case really do matter, and there are some that I really need to highlight to the court so they're not missed today, so that you are well aware of them when you consider this case. And particularly with this March 15, 22 email. I'll just call it as the email. It's the only email that we're talking about in this case. So I won't say 3/15/2022 every time. It is a fact that 729 West did not receive that email. It's a fact that Brent Rumis, the other property owner, discovered that email a couple weeks after it was sent. It's also a fact that the zoning inspector, when he sent this email in March of 2015, didn't know that there was a second property owner. The transcript, document 33, page 52, talks about this. He didn't know there was a second property owner. And in fact, he testified the township didn't have any records to show who the property owners were. And the inspector didn't bother to find out. He just assumed that Brent Rumis was the only property owner. And that issue is pretty well established in terms of the board even recognized that board member David Zelenik said, there may be confusion who the second owner was. If we knew there was a second owner and if the owner was notified. And
do you agree there was a meeting with the zoning inspector and some of the property owners? Do you agree there was a meeting before March 15 with the property owners and the zoning inspector?
There was not.
So your position is that they just got this email out of the blue. There was no conversation from anybody before, just got an email one day saying you're not a conforming use.
On March 2nd, another individual, third party, went to the township to ask some questions about this. That person informed my clients about this. So my clients did go to the township where they tried to meet with Inspector Wilson. He wasn't there. So they talked to one of the secretaries there. And so there was never an in-person meeting. And in fact, Tom Wilson will say, in the end, he never recalls ever meeting Tom Sims, who's a representative of 729 West. He recalls maybe only meeting with Brent Rumis at some point. Both of my clients testified they never met the guy.
And before the email was sent by the zoning inspector, was there a phone call also to some of the individuals in this case?
There was a phone call that the record reflects that no, you know what? Inspector Wilson said he made a phone call after he sent the email on March 15th. That he sent
Who
an
did he
email.
make that phone call to?
Pardon me?
Who was that phone call to?
To Brent Rumis, the person who received it, the person who the email was sent to.
And is there any dispute that the phone call was made?
There's a dispute. He said he talked to him on the phone. There's a dispute as to what was said.
Okay.
My client said he never talked about this. So yeah, there was a phone call that apparently Tom Wilson made after the email was sent on the 15th, but it was a phone call to one of the two property owners, and so one of the reasons why why it's important. Some of these facts are important because taking away a property right requires notice to the owners. It doesn't rest on the hope that owners will talk with each other about this, or that the assumption that they will. And frankly, the fact that this notice was not sent to all of the owners is really the easiest path to resolving this case, notwithstanding the other issues. And on pages 14 to 16 of our brief, we did talk about the Prairie View Township Board of Trustees decision, which I think is relevant. It doesn't contain identical facts because, in the world of zoning, all the facts are always so different. But this case does relate to a fact pattern where the zoning violation was sent to one of four property owners, and the court treated it as being sent to all four, finally reduced to judgment. And the Court of Appeals said, no, you didn't notify these other three. They never had an opportunity to come, and appeal. So the same result is true here. That 729 West was never served with this email, and so the dismissal of the appeal, at least as to 729 West, was improper. And importantly, the trial court determined that Brent Rumis was somehow a representative of 729 West, and nothing could be further from the truth from the record. The record, in fact, supports just the opposite conclusion, that Tom Sims was a representative of 729 West. And if you do look at transcript document number 21, you will see the entry on page 2. It says Brent Rumis and Tom Sims, and it has both of their phone numbers there. So this is not a representative situation. They're two owners, they were acting independently. So it's a fact that the landowners were not served with a written order. Now, if an ongoing violation had somehow occurred, Section 12.3A of the zoning code requires service of a written order. Well, the BZA says 12.3A is inapplicable. And they do so because they know the email is not a written order, and it wasn't served on both landowners. So we know that the email would not comply with this written notice requirement. So where does that leave us? Well, one of the reasons why the landowners argued that Section 12.3 applied is because Section 8 of the code, which talks about non-conforming uses, has no process or procedure, says nothing about how they are to notify these landowners. So, and Section 12 deals with enforcement of the zoning code.
Wouldn't they notify them at some point if they decided there was a zoning violation? If one day they found out about this and said, look, it's a zoning violation, you can't be doing this, they would have filed a action for zoning violation that had to give them notice of that, and that would have triggered the Rule 12.3 procedure. That's not what we have here, because they're not at this point alleging a zoning violation.
That's not what we have here. No, we filed the appeal out of abundance of caution because we didn't know what this was. It's an email. We don't know what it was. So we knew we couldn't just sit on our hands. So we had to do something. But 12.3 comes the closest in the code to how do we notify these guys about something. The BZA position is, no written notice is even required. A phone call is good. A verbal discussion is good. So if 12.3 doesn't apply, then, if a written order is not, if service of a written owner on a land order is not required to notify a landowner that their property rights are being deprived or taken, then what kind of notice is required? Well, I think then we're left with simply constitutional due process. And the bedrock there is that notice must be reasonably calculated under all the circumstances to apprise the interested parties, which, the question of whether due process requirements are satisfied, that's a legal question for the court. The BZA talks about this notice as formal notice. They refer to it sometimes as formal notice. I'll ask you the last time you received, formal notice via email of a property right being taken away. But I think very importantly, some facts do help us determine what kind of notice the BZA believes is reasonably calculated to apprise interested parties. And if you look, the notice of the hearing before the BZA, well, how was that sent out? It was served on both owners by certified mail. Transcript 14. It was served on both owners by regular mail. Transcript 15. The notice of the BZA decision served on both owners by regular mail. Transcript 30. And another fact showing how the township believes notice can be reasonably calculated is 12.3a of its own code, where it says, you got to serve service of a written order. So I think it's more than a bit ironic that we have a notice of a hearing and a decision being sent by certified and regular mail, and yet the initial notice depriving them of this right is sent by email to less than all of the property owners. It wasn't really, what would have made it reasonably calculated? One thing that could have made it calculated was an established form of email between the township and these parties. That never existed. There was no chain of email. This email, we don't even know how they got the email address. So,
and counsel, you're just now reaching into that. You're just now reaching in that 4 minutes. I wanted to let you know you may continue or reserve as you wish.
Okay, I'll use 1 more minute and then I'll stop. So I do want to remind the court of a Supreme Court decision where the Supreme in 1950 in Mullane Central Hanover said, when notice is a person's due, process, which is a mere gesture, is not due process. The means employed must be such as one desirous of actually informing the person. In this case, it doesn't appear that the township was at all interested in actually informing both property owners of this. At best, it's a calculated placeholder that the township knew wouldn't be read by both landowners, or at least certainly knew would not be read by 729 West. And whatever else this email is, it is certainly not formal notice, and it's inconsistent with due process, and I'll reserve the remainder of my time, if I may.
Certainly, to have just over 3 minutes remaining.
Thank you, I appreciate it.
Morning, Your Honors, and may it please the court, I'm Vince Bellucci with the Medina County Prosecutor's Office on behalf of the appellee, the Hinckley Township Board of Zoning Appeals. I guess I'll start with what Mr. Muniak is spending the most time on, which is, I guess, the third issue he presents, claiming that 729 West 130th should have been notified that the property no longer qualified as a non-conforming use. Well, we know that Mr. Rooms was one of the owners. 729 then, if you look at the record, did receive actual notice through its member, Mr. Sims, Tom Sims. And critically, Mr. Sims testified at the BZA hearing that he discussed the matter with Mr. Rooms after Mr. Rooms received Mr. Wilson's email. So that's actual notice. Notice is what's required to satisfy due process, and both owners had actual notice in this case. Both owners had a reasonable opportunity to appeal the BZA to the BZA within the 20 days, but they didn't do that. The Hay case cited by the appellants is distinguishable because that case involved zoning violations.
So your position is that oral notice is good enough here?
Correct. There is nothing in the ORC. There's nothing in the zoning resolution that says the form that the notice has to take in this scenario. It does say that it has to be in writing if you're informing somebody of a zoning violation. That's 12A, which has just been discussed. But when it comes to something like this would fall into the action, taking any appropriate action to prevent a zoning violation, basically is what's happened here. Under 12.C or 12C, it is what it is. And so there was the email sent, and then there was a follow-up phone call as well. And either it's our position that either one of those would have been sufficient, but both were done here. This is not a property right being taken away, as Mr. Muniak has said. It's not notice of any kind of a violation. This is sort of a preliminary. Hey, you are out of the non-conforming use now because you haven't had a liquor license for several years, really since before the pandemic. I will mention that there's several issues argued for the first time in this appeal that were not argued below and therefore are waived, including that the zoning inspector wasn't authorized to issue this determination. There's several pages spent on that in the brief. In the event this court does want to entertain that argument, the zoning inspector, Mr. Wilson, absolutely had the authority to do what he did in this case. You start with, again, 12.3C, which says that the zoning inspector may take any appropriate action to prevent a violation of the zoning resolution, which mirrors the language of revised code 519.24. And then the language of 519.14 says the BZA, the Board of Zoning Appeals, has the power to hear and decide appeals of, quote, any order, requirement, decision, or determination made by an administrative official. So they made sure to put plenty of words in there to make this as broad as possible in terms of what the BZA's jurisdiction is here. They clearly have jurisdiction over this, whatever you want to call it. A decision or a determination. This email certainly was one of those, and phone call. This was not an ad hoc observation, I think is the term used in the brief, as they're trying to argue this clearly was either a decision or a determination. The appellants, they're claiming that the email was not something that was even appealable, yet they appealed it to the BZA. They claim that the BZA didn't have jurisdiction, but they want the BZA, but they go to the BZA then to make their case. The appellants claim that Mr. Wilson's use of email to notify them of his decision violated due process. However, email notification is a widely recognized and accepted method of service in Ohio and federal courts. In fact, all federal court filings have to be made electronically. And in the Supreme Court of Ohio, all filings have to be made through their e-filing portal. Then the filings get served automatically by email to all the parties. In fact, the appellant's attorneys in this case even serve their brief by email.
Well, in circumstances where there's service by email, isn't there an outline procedure for that type of notice, like which email to send it to and rules? I mean, is there a government setting where email is appropriate service without some standardized rules about that?
Well, I think there are in the case of the federal courts and the Supreme Court, in terms of all the parties to the case who have to give their emails are sent the emails, and here the email was sent to the emails that the email that Mr. Wilson had been provided. So there's nothing saying that that every interested party or owner or anything like that has to be served with the email. Those kind of rules just don't exist, as Mr. Muniak said. The zoning resolution's silent on it. The ORC's silent. So ultimately, you have to go to general notions of what constitutes due process. And if you look at this, the totality of this, there was due process here. Again, the statute doesn't even say that the zoning inspector's decision has to be in writing. So again, even just a phone call would have been sufficient. It satisfies due process in this case because it was clearly received by both of the appellants, and it gave them the notice necessary to allow them to file the appeal. In terms of what the email actually said, that's another argument that's being raised for the first time in this appeal, saying that that was inadequate in some way. Mr. Wilson's statement in the email was simply the following. I'll quote it. Based upon the Hinckley zoning resolution, the building and land located at 729 West 130th no longer qualifies as a non-conforming use. That's the extent of it. It's unclear why the appellants think this email should have said more. I don't know if they wanted it to be violated at that point or what, but at this preliminary stage, there was no indication that the appellants were operating the property in violation of the zoning resolution. In fact, there was no indication that the business had operated at all since losing its liquor license in January of 2019. So at that point, there was no reason for Mr. Wilson to be threatening legal action or injunctions or anything like that. The other two pieces of information the appellants say should have been in it, which is that the property could not be used as a tavern and that doing so would violate the zoning resolution, that should have been self-evident and obvious from Mr. Wilson's statement that it no longer qualified as a non-conforming use. And there's also this idea that Mr. Wilson's email had to say something about that they could appeal the decision to the BZA. That's not required either under either the zoning resolution or the Ohio Revised Code or due process, frankly. The appellants were deemed to know the law, and ignorance of the law, as this court is aware, is never an excuse. You're deemed to know what is in the zoning resolution and what isn't, what's in the ORC and what isn't. If there are no further questions, I would simply ask the court to affirm the judgment of the trial court. Thank you.
Seeing none, thank you, counsel. If you give me just 1 second, Attorney Muniak, for me to reset the clock, you'll have 3 minutes and 10 seconds remaining for rebuttal. You may proceed, except for you're muted.
Nothing in the record shows that my client provided an email to the zoning inspector. That's nowhere in the record. The record shows that Brent Room is opened it 2 weeks later. There's no established chain of communication. When counsel talked about the parties talking about this, they were talking about the problem that became apparent on March 2nd. They heard it from a third party. They didn't hear it from the township. That's a problem. They heard there was a problem from a third party. So that's the problem that they were talking about. They weren't talking about an email or being deprived or no longer able to use this non-conforming use. I want to quote the chair at the hearing who said, and I can only speak for myself on this board, but it's very hard for me to believe that you are partners in something this serious where you're being put out of business that you wouldn't discuss it. And the chair was right about one thing, that this email essentially puts the landowners out of business. And it's also hard for me to believe that you could do that via email. So I know you've been waiting for the parade of horribles. You referred to some of them, and here they are, right? The parade of horribles is that, you know, the BZA position is, look, when the code doesn't require service of a written order when taking away a property right or doing something like this, an email is not necessary. A phone call is sufficient. Verbal notice is sufficient. Or if you look through the transcript 33 of the chair, no notification is even required. So, you know, the zoning world amongst litigation folks is considered the Wild West. And now you've got, in addition to this, deprivations being made by phone calls. He said, she said, no written notice at all, verbal discussions that we don't know what took place. That's not a fair playing field for these folks. And I think our longstanding commitment to due process requires much more than that in this case. And certainly the township shouldn't be rewarded for its failure to specify a process and procedure for making determinations that a property no longer qualifies as non-conforming use. In a decision affirming the trial court can hardly be said as one construing the zoning code in favor of the landowners, which it should. And there is silence in that code. Thank you very much for your time.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk of courts to all parties to this appeal. It will also be posted on the Ohio Supreme Court website. Thank you again, gentlemen, for agreeing to appear by Zoom. Have a wonderful day.